morning, Your Honors. My name is John Ferguson. I'm the appellant in this case, appearing this morning pro se.
Okay, and Mr. Ferguson, you are not an attorney, is that correct?
I beg your pardon, sir?
You're not an attorney?
I am an attorney.
Oh, you are an attorney, okay.
I've been long retired. But
Okay, I'm sorry, I missed that somewhere, I apologize. So, I don't have to go through my usual routine of when I have someone who's not licensed, so.
I'd like to reserve, if I may, 5 minutes for rebuttal.
Yes, sir. Yes, sir.
Your Honors, I want to address this morning 3 errors which we believe were made by the trial court, which are grounds for reversal of the court's judgment in this case. Those 3 issues are, first of all, the court's refusal for some strange reason to address the issue of the intent of the decedent / settlor of the trust that's at issue here. Secondly, we would argue that we did in fact meet our burden for proving grounds sufficient to cause the removal of Truxton under 3515-706B 1, 2, and 3. And finally, I want to address separately the issue of the court's abuse of its discretion in refusing to appoint the person who had been chosen many years ago as successor trustee to Truxton. First of all, with regard to intent, the lodestar in Tennessee and in other jurisdictions with which I'm familiar, when it comes to construing a will or a trust, is for the court to determine the intent of the testator, trustee, or settlor. And unless that intent is unlawful or inconsistent with public policy, to implement in full the intent of the testator settlor. I would argue that the intent of Mrs. Graham in this case is quite clear. She was advised by a very skilled member of the Nashville Bar when she executed her will. And I think that her intention was clearly stated in the will with respect to the issue of material purpose, which was one of the grounds that, or really the only ground that I can see that the court really addressed directly when it refused to remove Truxton. I couldn't find a case in Tennessee on point, but I believe the Finsky case that I've cited in the brief is at least persuasive or instructive as to some of the factors that another court considered in a case of first impression with regard to what the material purpose of a trust is. And essentially, Finsky says it's necessary for the court to find some very specific concern or some very specific purpose that the testator settlor intended to further by their choice of a trustee. Here, the trial court said that it's a material purpose of this trust that's at issue that the co-trustee, the successor co-trustee, be a Tennessee corporate fiduciary. But there's absolutely no basis whatsoever in the will or in the trust provisions that are set out in the will. There's absolutely no basis whatsoever in the record at trial in this case to support that position. The judge didn't address it except in one sentence when he said that this would be a violation of a material purpose of the trust to assign anyone as trustee other than a Tennessee corporate fiduciary. Secondly, we would argue that we have, in fact, met our burden with respect to the dismissal of Truxton under 3515-706B 1, 2, and 3, which are the 4 cause if you will, dismissal provisions. The record is very, very clear that Truxton has either through lack of skill or lack of will or possibly a combination of both, refused to act as a co-fiduciary as required by Tennessee law. They have acted unilaterally on a number of occasions, and as of today, they're deducting money from this trust for fees every month that no one has ever approved. The trial court judge just ignored the issue when we asked him to review it.
Well, I was going to ask you that.
We have no understanding whatsoever of the basis for calculating these fees.
The trial court did not find any for-cause matters, did it?
No, it did not, Your Honor.
Okay. So what you're arguing is inconsistent with the findings made by the trial court?
That's correct.
Okay.
We believe that this unilateral action by Truxton in establishing a trust, an account with themselves, and then paying themselves fees over the course of several years without the fees ever having been examined was clearly a violation of both B1, B2, and B3.
Let me pose a question to you then. This court obviously will review the record, will review the findings of the trial court, and make our own decision about that. Assuming this court were to find that there were no grounds established, what does that do to your argument today?
Well, there's a fourth basis for we believe overturning the judgment of the lower court, and that's the so-called no cause provision under 3515-706-B4. And it's our position that we also met our burden with respect to the proof there. The only issue that the trial court addressed in that respect was this material purpose issue, and as I've already, I think, demonstrated, there's no basis in the record, there's no basis in the will for finding that a material purpose of this trust was to have a Tennessee corporate fiduciary serve as co-trustee. The will provided initially, and has never been changed in that respect, that Janice Haddon, Mrs. Graham's niece, was to be the successor co-trustee. That's never been changed. There were plenty of opportunities for that to be changed by Mrs. Graham or by her counsel if what they had intended was that the co-trustee be a Tennessee corporate fiduciary, but that was never done. The will reads today as it did initially when it was executed. Finally, I would like to address what we believe is a serious abuse of discretion by the trial court judge in refusing to appoint Ms. Haddon as successor co-trustee. There's absolutely nothing in the record whatsoever to support the trial court's decision to not appoint her as co-trustee. She was chosen by Mrs. Graham, not just in this case, but in the case of another trust, actually, that Mrs. Graham set up to serve as a co-trustee. And the court didn't address in any way whether or not she is a suitable co-trustee to replace Truxton. So we would argue that that's a serious abuse of discretion that also is grounds for reversing the trial court's decision.
Let me ask you, I think you have requested that the appellee be required to repay the fees that were paid to it without court approval or without the approval of
return
the
those to the trust, Your Honor, yes.
Right. Did the court rule on that?
No. The court just ignored that issue.
And do you make that an issue on appeal?
Absolutely, Your Honor. In our brief and at trial and in our original petition, we requested that those fees be returned. There was an argument made by the appellee that we had waived this claim, but I can't imagine what reasonable basis anyone could give for a waiver of that claim. It's clearly set forth in our petition. There was testimony from 3 different witnesses at trial asking that the fees be returned because they'd been taken improperly from the trust, and we've argued it in our brief as well.
What is the amount of the funds under management by Truxton?
Well, at this point, there are 2 separate funds, if you will. There's what is remaining of the estate assets, which is something on the order of $300,000 or so, I believe.
I'm asking about the trust itself.
And then the trust itself, what was transferred into the trust, my recollection was at that point about $1.6 million. Who knows what it's worth today, but.
So no additional funds have been transferred into the trust?
No, Your Honor.
All right. That's all I have.
Thank you, sir. You've got your rebuttal time.
Good morning, Your Honors. I'm Paul Gontarek of the Nashville Bar, and I represent Truxton Trust Company in its capacity as the co-trustee of the Katherine D. Graham Trust. This matter was a 2-day evidentiary hearing that the trial court conducted. There was about, I think, 5 witnesses that testified, multiple exhibits. It was a trustee removal action under 3515-706 of the Tennessee Code. And the trial court, after hearing all of the testimony and evidence, made a specific determination that Truxton had committed no acts of malfeasance, misfeasance, or nonfeasance that could justify its removal as co-trustee. We would argue that implicit within that the court did address this issue of trustees' fees, that there was a finding by the court that Truxton had not committed any malfeasance with respect to its administration of the trust that would justify its removal or otherwise. That really answered, if you look at the way that statute lays out, the first 3 prongs of a way in which a Tennessee trustee can be removed. Under B1, did they commit a serious breach of trust? The trial court, after 2 days of testimony, determined that Truxton had not. Under B2, did Truxton show a lack of cooperation concerning the administration of the trust? Again, after 2 days of testimony, the trial court found that it had not, and then under B3, was the trustee unfit or unwilling to administer the trust? And again, the trial court, after 2 days of testimony, found that Truxton had not violated that provision either. So really where this case comes down is on B4, which is the no-fault provision under the Tennessee Code, which allows that a trustee could be removed if the removal is requested by all the qualified beneficiaries, which was the case in this particular circumstance. But importantly, the court also has to find that the removal of the trustee best serves the interests of all the beneficiaries and is not inconsistent with the material purpose of the trust, and a suitable co-trustee or successor trustee is available. And what I would submit to your honors is that after 2 days of testimony, the trial court determined that the removal of Truxton was not in the best interest of all the beneficiaries, that the removal of Truxton Trust was inconsistent with the material purpose for which the trust was designed, and thirdly, that the court determined that a suitable co-trustee was simply not available. What the appellant and other parties in this case that are not part of this appeal. Did the
trial court determine that third portion, or did the trial court simply say if there was a handoff, so to speak, then it had to be another basically commercial trustee?
I think the court, both actually. The court did make the determination that if a successor trustee was going to be appointed, it needed to be a corporate fiduciary. That's true. The court also at TR 103 in the circuit court's order made the determination in the court's appraisal based on the petitioner's testimony and court's observation of their respective demeanors as well as appellant's past interactions with Truxton that if Ms. Haddon were permitted to serve as co-trustee, that was one of the individuals that they sought to have appointed, that the appellant would most likely continue his pattern of controlling behavior and exert pressure on both Ms. Ferguson and Ms. Haddon so as to eviscerate any semblance of independence on their part. That's trial record page 103 of the Circuit Court's order. That finding, I believe implicit within that finding, is a determination by the trial court that Ms. Haddon would be not a suitable co-trustee to serve as co-trustee of this trust. The petition, or I guess it's a second amended petition, actually sought to have Truxton replaced as co-trustee with either the appellant, Mr. Ferguson, or Ms. Haddon. And the court really did go through and look at both of them as potential successor co-trustees. The court also in trial record page 103 made the determination that the appellant was not a suitable candidate to serve as successor co-trustee of the trust because he has treated Truxton in a rude and unprofessional manner, not in keeping with the role of a fiduciary. So really the trial court made the determination both as to the appellant, that he should not serve as successor co-trustee, and also Ms. Haddon, that neither of them were suitable co-trustees. Therefore, the trial court exercised its discretion to suggest to these individuals that they needed a successor corporate fiduciary to be appointed, and allowed them the discretion and opportunity to go and interview a corporate co-trustee to be appointed. They've not availed themselves of that. They instead have availed themselves of their right to an appeal at this point.
What was the basis on which Truxton became trustee?
So Truxton Trust was appointed as co-trustee of this trust under the second codicil of the will. So if we were, this is a testamentary trust, right, that's created under the terms of the will of Ms. Graham. So under the will of Ms. Graham, Truxton serves as co-executor with Mr. Ferguson, although he's since been removed by the trial court as co-executor. And then under the trust that's created under there, originally, Mr. Charlie Cornelius, who was the scrivener of the will, was appointed to serve as co-trustee of the trust with Ms. Ferguson. Under the second codicil of the will, Truxton Trust Company was named as the co-trustee of the trust to serve with Ms. Ferguson. Your Honor,
The reason I asked that question is I thought I heard Mr. Ferguson say that there was no provision in either the will or the trust for y'all to be named, so that's not correct.
That's not correct.
All right.
So the will names, the second codicil to the will specifically names Truxton Trust Company to serve as the co-trustee of the Katherine D. Graham Trust.
And then if Truxton couldn't serve, does it name a successor trustee?
That's where Ms. Haddon comes in. So Ms. Haddon is specifically named in the instrument to serve as a successor if for some reason Truxton Trust Company is unable to serve further as co-trustee. And I would point out to Your Honor that...
Well, to the extent that it names a related party as a potential successor, how do you, looking at that, make the determination that the appointment of an independent co-trustee was a material purpose of the trust?
That's a good question. So as it relates to the material purpose, our position on this is that the settlor, the decedent in this case, was very clear about the way in which she structured both her estate plan under her will as well as the testamentary trust that was within the will. In both cases, she made the independent determination to have serving as executor an independent corporate fiduciary, Truxton, to serve with Mr. Ferguson as co-executors. Under the trust, under that same instrument, she made the determination initially to have an independent party, Mr. Charlie Cornelius, an attorney here, member of the bar, to serve with Ms. Ferguson as trustee. Later, when she amended to the second codicil, she specifically named Truxton Trust Company to serve as a co-fiduciary along with an individual. So from that, we can make the determination that it was material to her to always have in these positions of power an outsider, a corporate entity or individual, initially Charlie Cornelius, to serve along with a family member. And from that, it's hard, you're essentially extrapolating at this point based on the four corners of the instrument. But throughout the way in which she structured her estate plan, the decedent in this case, she was consistent in always having an outsider serve as a co-fiduciary along with a family member. And from that, we can glean that one of the purposes of her estate plan was to have this independent party act.
Is the estate still open?
The estate is still open.
And was this action filed under the same cause number as the estate?
No, it was filed as a separate action.
Well, to the extent that the trial court didn't rule on the issue of repayment of a reimbursement of fees, do we have a final judgment?
If Your Honor determines that the trial court did not make a specific ruling on the attorney fee issue and that it was actually properly before the court, then this would not be a final judgment because that issue would not have been decided at the trial court level.
But when I'm talking about attorney fees, but reimbursement of the fees that Truxton withdrew from the trust funds, is that right?
That's right. Right.
Okay.
And so what their argument on this is essentially that Truxton is paying itself a trustee fee, which it's permitted to do under Tennessee case law as well as the instrument itself. And they're saying that Truxton should not have paid itself that fee. So essentially they're making a breach of fiduciary duty argument as for improper payment of fees. The court did make a finding that that Truxton had not committed any instance of malfeasance or misfeasance with respect to his administration of the trust, which from our perspective encompasses and subsumes that particular allegation.
But doesn't specifically address that
It did not
allegation.
specifically address it.
And how were those fees determined?
So a trustee fee is determined pursuant to a schedule. So it's based on the value of the trust, and there is essentially, a certain number of basis points charged per thousands of dollars that the trust is holding.
And so an annual fee of roughly $24,000 is an appropriate fee where the funds under management are only $1.6 million?
That's correct, Your Honor. And that's generally how a corporate fiduciary functions, is pursuant to a fee schedule. The fee schedule that was used in this particular case had been in place for a long period of time, in fact, all the way back until the point where the decedent had first made contact with the bank. The decedent, this is in the trial court record, there's testimony to this, was a longtime customer of the bank, lived down the street from the bank. The bank essentially treated her as family, took her out to dinner on Sunday nights. There was testimony to that effect at the trial court. She was well familiar with the bank, knew what they were charging, and was specific about wanting to appoint them to serve as co-trustee and co-executor of her estate in this particular matter. Your Honor,
Were the fees actually litigated?
They really weren't, Your Honor. I will say this was a 2-day trial, and the plaintiff's case was presented on the first day of trial, and then the second day we had testimony from bank executives in closing argument. And the thrust of the case, if you read the transcript or look at the statement of the case, it's really about removal. What they wanted was Truxton to be removed as co-trustee and Ms. Haddon or the appellant, Mr. Ferguson, to be appointed as co-trustee. There was not argument from, at that point in time, they were represented by counsel, Attorney Pat Mason over Shelby County Bar, and there really wasn't an argument from Mr. Mason that a breach of fiduciary duty had occurred with respect to the trustee fee issue and that a certain sum of money needed to be repaid to the trust. There's a absence of that argument at the trial court level. I understand what's in the pleadings, but there was just not a discussion of that during the 2-day trial.
Or was there evidence introduced about the amount of fee that was charged?
To the best of my knowledge, Your Honor, no. The exhibits in this case did not encompass, to my memory, the specific amount of trustees' fees that were being paid to Truxton. I believe that there is a statement of the trust in the record, Your Honor, that just shows what the value of the trust was.
What standard do we use as we analyze this case? Are we applying the abuse of discretion standard, or we looking into this de novo?
That's a good question, Your Honor. Not knowing I was going to be in front of this panel, I cited in my briefing to a case called In Re Estate of Edmonds. It was a Shelby County case that was decided by the Court of Appeals in 2019. And Your Honor, Judge Stafford's actually the writer of this opinion. And I don't know if you'll remember this one or not, but it's an estate case, and it relates to whether or not the trial court was appropriate in removing the decedent's, the decedent died and his spouse was qualified initially, or excuse me, his mother was qualified initially to serve as administrator. And the trial court removed the decedent's mother from her position and instead appointed the guardian ad litem of some minor children to serve as administrator. And so this panel actually was the one that heard the case and made the determination that the trial court was within its discretion to remove the mother. And the statutes that relate to removal of an administrator are slightly different than a trustee, but they're pretty close. And Your Honor, Judge Stafford mentioned, given the permissive language used in section 30-1-151 and 35-15-706, which is our statute we're dealing with, Your Honor said, it appears that the trial court retains discretion with regard to its removal decisions. And so Your Honor, in that case in 2019, applied an abuse of discretion standard. And I would submit to Your Honor that that is the correct standard to apply in this case because the language of section 706 is also permissive. It's under B, section B, a court may remove a trustee. That same language is present in the administrator removal section that was discussed in the 2019 case. It's present here in the trust case too. I think this is an abuse of discretion standard that this court would look at this decision of the trial court.
Or everything else.
Thank you, Your Honors.
Yes, sir. I'm sorry. I thought you were coming up.
Mr. Gontarik is a master at taking liberty sometimes, I think, with the record. Here's some of the testimony at trial with regard to Truxton's fees. Janice Dinkins Ferguson, co-trustee, said Truxton is charging a fee that I feel is unreasonable. As I said earlier, I think their fees are totally outrageous. Ms. Haddon had testimony to the same effect. I testified at length about the fees and about the fact that I had actually been in negotiations with both UBS and Truist, at that time SunTrust, and that I had negotiated fees that were far less than the fees that are being charged by Truxton today.
Was there a specific amount ever asserted that needed to be repaid, or was it just
all of the fees was our position.
I understand the position, but was there a dollar figure attributed to that?
Well, I did a calculation at one point that showed the fees at that point had exceeded, I believe, $70,000. I haven't recalculated the fees as of today, so I couldn't tell you.
That was your trial testimony?
Yes, Your Honor.
Okay.
And was that on the first day of the trial?
Yes, Your Honor.
We have a transcript for the first day, is that right?
Yes, Your Honor.
Okay.
We have a highly contested statement of the evidence as the only basis for the court's decision on the testimony at the second day of the trial. I also wanted to mention another provision of the Tennessee Uniform Trust Code that I think is very definitely in play here, and that's 35-15-704. That provision of the trust code establishes, in cases where a trustee is to be replaced, a mandatory system of priorities for replacing the trustee. And essentially what the statute says is that the court is to look first at whether or not the settlor of the trust had chosen a successor co-trustee, and if so, it's mandatory that the court appoint that person as successor co-trustee. The second priority is have the qualified beneficiaries chosen someone whom they wish to serve as co-trustee. In this case, there were 3 witnesses on the first day of trial, Ms. Haddon, my mother, Janice Ferguson, and myself. There were also 4 witnesses on the second day of the trial who sought to intervene. And they're 4 young women who are highly intelligent, well-educated, accomplished young ladies. One's an assistant U.S. attorney of Massachusetts. Another's on the Vanderbilt faculty. She's an academic physician. Another's a trust and estates attorney. And the 4th one is a senior corporate manager. These are the 4 daughters of myself and my sister, who are the terminal beneficiaries of this trust that we're talking about. All 4 of them also testified that they wanted Truxton removed and that they felt there was absolutely no reason for them to fear their father, their mother, their aunt, and actions that might be taken by those 3 individuals to erode or improperly impact them as the terminal trustees of this trust.
Let me ask you, from the ruling, the court was inclined to replace Truxton if you agreed to a corporate co-trustee, and I gather from your comments just now, you'd been looking at UBS and perhaps some other company.
Well, UBS and Truist both we've been in discussions with, but Your Honor, as a financial advisor to the trust, not as the co-trustee, Mr. Gontarek and the court totally ignored the provision in Mrs. Graham's will that appoints Janice Haddon as successor co-trustee. It's in my brief, it's in the record. They are specifically appointed successor co-trustee. And what the trial court did is simply write that provision out of the will. It just ignored it. And the court was not allowed to do that. It was not allowed to ignore the clearly expressed intent of Mrs. Graham when she selected, many years ago, long before Truxton Trust even existed, she selected Ms. Haddon as successor co-trustee, and that provision was never changed.
All right, sir. Thank you very much.
Thank you.
Thank you to both counsel. We understand and appreciate both your oral argument, your written argument. We will take this matter under advisement and attempt to render a judgment at the earliest possible time. I believe that concludes our morning docket. We will be in recess to the call of the docket this afternoon.